Congratulations, Judge Lowe, for another year. So with that, I'd like to now introduce Jim Woods for his legal update.
Hi, we're going to give you I am going to give you a quick update on some legal and legislative developments that we believe affects your business either immediately or will soon affect your business, and we'll try to help you navigate through some of those minefields. We're going to divide this into two sections, mainly focusing on California, but also give you a federal update, some of the developments surrounding NRRA and the FIO, the Federal Insurance Office, which has been newly created. With respect to the NRRA, as Pat and Joy have both indicated, this is the so-called Non-Admitted Reinsurance and Reform Act. It was part of the Dodd-Frank legislative financial services reform, and via AB 315, which was enacted and became effective on July 21st of last year, the principal rule became under California that California law will govern all placements, whether non-admitted placements with non-admitted insurers, where California is deemed to be the home state. So wherever California is deemed to be the home state, California law will govern. You are required as a surplus line broker to make that determination. You may rely upon the good faith representations of your insureds. And there are two principal guiding lights here. One, the home state is if the insured's principal place of business is located here, and secondly, or the residence, or secondly, not and, but or secondly, 100% of the risk or exposure is located in the state of California. So if you have a situation, even if the residence is outside the state, but 100% of the exposure is here, California is the home state, and likewise, the risk could be spread out throughout the United States, but if the insured's principal place of business or residence is here, then California is the home state. This is particularly significant because we have to make a determination on how to remit taxes. Now, the old days, as you may recall, we had to allocate taxes amongst the many states depending upon things like gross receipts and locations and employees and the like. The NRRA simplifies that. Surplus line brokers are required to make a tax payment on 100% of the premium charged, regardless of the amount allocated to California when California is the home state. And also under 315, premium tax for non-U.S. risks or exposures will not be collected. So if you have a multi or global risk, a portion of it in Germany, some of it in California, don't worry about collecting the taxes on the overseas portion, just the California portion of the risk, or whatever's in the United States if California is the home state. We also have issues of related to Leslie and Lasley. The old, for context, the old rule was that the Department of Insurance had created a list of eligible surplus line insurers. And the insurers would apply and annually update their list and pay application fees and the like, and then be added to that list. That list technically has been disbanded. It really has been replaced by a different list called the list of approved eligible surplus line insurers. And this is somewhat unique in California. No other state has done this. Under the NRRA, there are two fundamental requirements for you to choose a non-admitted insurer in order with whom to do business. One is that it is licensed in another state for the lines of insurance in which you choose to write, if it's a foreign insurer, and if it's an alien insurer, and that it have 45 million in capital and surplus. If it's an alien insurer, it must be listed on the NAICIID list. California, that will also work in California. However, California has created a list of approved surplus line insurers, which the California Department, like in the old days, reviews carefully. That list I like to think of as enjoying the so-called good housekeeping seal of approval. This means if it's important to you and your client that this particular list has been given extra vetting by the insurance department, the insurance regulators, and as a result, your customer may enjoy more comfort from that. So we encourage you to use and take a look at those companies on the Lasley list, but you are not legally precluded from placing business for others that would otherwise qualify. Just as a procedural matter, every insurer on the Lasley list was grandfathered onto the Lasley list. However, that is now beginning to run off upon annual renewal. And as a result, new insurers are applying for Lasley listing. There are 3 applications. One has been approved, 2 others are pending currently, but we're aware of other ones that will be hopping on board. Now, if you choose to place business with a company other than a Lasley listed company, then you're going to have to file a certificate of capital and surplus issued by the domiciliary state with the California Insurance Commissioner's Office. Also, a certified copy of the insurer's license issued by the domiciliary state. And finally, disclose any notices of any actions pending against the insurer. So it's sort of a mini filing. It's not the full former Lasley filing or the new Lasley filing. It's a mini filing for those that are applicable. Now there's some broker reporting requirements that we have with respect to your annual report. You are going to have to indicate the total amount of premium. The total premiums for single state risk, that's where 100% of the risk is in the state of California. And for multi-state risk, the commissioner wishes for you to identify how much was allocated to other states. So even though for tax purposes, you don't have to make that allocation, for reporting purposes, you do have to make that allocation. In effect, the commissioner is asking for some assistance on monitoring where a lot of this business is headed. And then with respect to record retention, we also have to be mindful of the things we have to keep and maintain. We need verification that the insured is a California home state insured, verification that there's qualification for commercial or industrial insured exemption, whether or not the policy is a single or multi-state policy, and data is necessary to allocate premiums to the other states. So be mindful of the fact that if you ever have to undergo scrutiny by the insurance commissioner's office, you will have to produce those documents. There are some transition rules to try to make life a little bit easier. I think we're kind of beyond the transition stage in a practical sense, although those rules continue until October of this year. And they're, fundamentally it meant that between January 1 of last year and July 20th, business policies with effective dates between those periods was considered to be business done as of the policy's effective date. And that would cover cancellations, endorsements, and also installment premiums. And thereafter, the new rules would apply. If you have questions about that, or if you have a unique thing, call the surplus line office and we'll help you walk you through it. We also have some reinsurance components to the NRRA. Remember, this is the Non-Admitted Reinsurance and Reform Act. And fundamentally, it boils down to the domiciliary state controlling issues of cessions to reinsurers and also controlling whether or not there are any solvency issues regarding that. California is implementing or expected to propose some legislation incorporating some of those principles. They've already issued a bulletin 2011-2 regarding credit for reinsurance, and with respect to professional reinsurers, they've indicated how they're going to handle this in terms of solvency type issues. Let's switch horses for a second from 315 and NRA and focus on a couple of other things that may affect you. One is the delegation of reporting requirement. Oftentimes in the past, we've had a situation where two surplus line brokers were involved in a transaction and nobody knew which one was supposed to make a filing, or there was a presumption that one would and the other did, and then what would happen, was it a legal filing or not? So SB 131 has helped clarify that. Fundamentally, we have a transaction broker, the one who really negotiates the risk and remits the premium and the like, and we have a delegation broker, the one who is delegated the responsibility to make a filing. If there is such a delegation, that delegation must be in writing, signed by both of the brokers. I was thinking this morning as I was looking at this, it actually raised sort of a interesting little sidelight. Could you do this by email and through e-sign, and California's form of e-sign, will that in effect act as a signature? This is something we may talk to our colleagues at the insurance department about to try to make this transition as smooth and as efficient as possible. With respect to AB 2404, another piece of legislation that will affect you, return of unearned premium calculation and disclosure requirements. Be mindful of the fact that there are certain disclosure requirements if, in fact, you are not going to prorate the policy upon a cancellation, and you have to be upfront about that with the insured. This is a consumer protection measure. Technically, this does not state that, the law does not state that this directly applies to surplus line brokers. Nevertheless, we encourage you to follow that. It is not too difficult to follow, and frankly, we think that it's a good consumer measure, and therefore we think that you should follow it. And then let's switch federally real quickly here on the NRA and any update. We have 45 states now that have require a tax on 100% of the premium if that state is deemed to be the home state of the insured. Interestingly, there's only one state that doesn't require it, and that's Colorado. And they'll only tax a portion of the premium allocated to Colorado. For what reason, I'm not quite sure, but they're kind of odd in that regard. We have Iowa, Minnesota, and Wisconsin having pending legislation in two other jurisdictions. The District of Columbia and South Carolina have yet to address the issue. You may recall there was a big debate on the implementation of all this at the outset as to whether or not we would, as the NRA allows us to go into compacts, enter into compacts, states enter into compacts, whether or not those would become a political reality. We have two compacts. One is SLIMPAC, the Surplus Line Insurance Multi-State Compliance Compact, and the other is the Non-Admitted Insurance Multi-State Agreement, NEMA. SLIMPAC was sponsored by an industry component and NEMA by the NAIC. SLIMPAC is not triggered until there are 10 states compacting. We have 9 currently. It covers both taxation and uniform eligibility for non-admitted placements. The Non-Admitted Insurance Multi-State Agreement, NEMA, has 10 states compacting. It will not be effective anytime prior to July 1 of 2012. And then finally, we have the creation of the new Office of Insurance Information. This is, it's brand new. It's being run by its first director, Mike McRaith. McRaith used to be the superintendent of insurance in Illinois. He is very well respected by regulators throughout the United States and by the insurance industry. And Jerry and I had an opportunity to meet with him in New York recently, about a week ago, at the Insurance Information Institute annual meeting, heard him speak. He's a terrific person. He's going to help lead the United States and its regulatory viewpoints vis-a-vis global issues. He'll interface with a lot of global regulators. He doesn't have enforcement power. He does have subpoena power. And I think he'll be a wonderful resource for regulators in the industry alike. And with that, I'm done. Thank you.